The high-powered defense team for Sean Diddy Combs is demanding that the prosecution hand over information about what they plan to claim at Combs' upcoming trial and the witnesses they plan to call, and they say they need this information now to prepare a real defense. I've got the latest court filings in this ongoing legal saga. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. The trial of embattled music mogul and entertainment titan Sean Diddy Combs is going to be here before you know it. He's scheduled to face a jury in May on federal charges of racketeering conspiracy, sex trafficking by force, fraud, or coercion, and transportation to engage in prostitution. Combs' lawyers are actually, though, trying to get that last charge thrown out, calling it racist. We'll get a little bit more into that later on, but Combs has consistently denied any wrongdoing, and his attorneys say he is looking forward to defending himself in court. And the key word there, defending. They need to put on a defense, because when it comes to the trial, the defense and the prosecution, they have been overwhelmed with discovery, terabytes of data that has likely resulted in possibly an information overload. There's a lot of information here. But one thing the defense says it doesn't have is a complete list of witnesses the government plans to call. And without that, the attorneys are saying we won't know what we're up against and we can't properly prepare a defense. So they've submitted a letter asking the judge overseeing this criminal case, Judge Arun Subramanian, to finally rule on a motion for a bill of particulars, which was filed months ago. So to really understand what's going on here, we actually got to go all the way back to October, what was going on the docket at that time. Because at that time, and even now, Combs has been locked up in the Metropolitan Detention Center in Brooklyn. And back in October, he was there for several weeks. He was arrested in New York in September pursuant to a grand jury indictment from the Southern District of New York. And the main allegations from prosecutors are that he used his wealth and his influence to intimidate people into performing sex acts with commercial sex workers for his own gratification. And they claim he was heading up a criminal enterprise that was involved in all sorts of illicit activity, from arson to kidnapping to sex trafficking. But we go back to October 15th, and Combs' attorneys filed their letter to the court. And it said, "We write on behalf of our client, Mr. Sean Combs, pursuant to Federal Rule of Criminal Procedure 7, to request that the court direct the government to identify its alleged victims so that Mr. Combs can prepare for trial and to allow defense counsel to ensure compliance with Local Rule 23.1.1. Now, a bill of particulars is a written statement of charges or claims that the government is making, establishing the issues of the case. It provides a little bit more details, a little bit more of specificity. It helps the defendant prepare for trial, make sure there aren't, any surprises at trial. And the defense noted in their letter to the judge, quote, "This case is unique, in part because of the number of individuals levying allegations against Mr. Combs due to his celebrity status, wealth, and the publicity of his previously settled lawsuit, and the grand jury leaks and false inflammatory statements by the DHS agents as outlined in our previous motion. This has had a pervasive ripple effect, resulting in a torrent of allegations by unidentified complainants spanning from the false to outright absurd." Essentially, it's how do we know who's going to be part of this criminal case when there's been already so many lawsuits filed against Sean Combs, so many accusations? We got to be clear about what we're defending against. And by the way, as you heard, the defense had previously accused the government of leaking information to the press and the public, something the U.S. Attorney's Office strongly denied. And since then, Combs is faced with even more lawsuits in both federal and state court as more Jane and John Does came forward to accuse him of rape and sexual assault. By the way, I have to say this. There is an issue that is affecting a ton of people right now. It's personal debt. We've all felt the pressure under credit card bills, personal loans, medical bills. Getting out of debt can feel impossible, but it doesn't have to be. Our sponsor, PDS Debt, offers a customized solution to help you manage your debt. With their technology, they go beyond the numbers to really understand your unique financial situation and come up with a clear path to get you back on track. Here's the best part: no minimum credit score required. So whether your credit score is bad or fair, they're here to help you pay off your debt faster and start putting your hard-earned money back into things you love. Every day you wait, it is costing you money. So get started with your free debt analysis in just 30 seconds at pdsdebt.com/sidebar. But now we go back to the defense's letter. Quote, "Bills of particulars are appropriate to permit a defendant to identify with sufficient particularity the nature of the charge pending against him, thereby enabling defendant to prepare for trial, to prevent surprise, and to interpose a plea of double jeopardy should he be prosecuted a second time for the same offense. These principles are applied with particular care when the government charges RICO, as it has here. As the Second Circuit explained, with the wide latitude accorded the prosecution to frame a charge the defendant has conspired to promote the affairs of an enterprise through a pattern of racketeering activity, comes an obligation to particularize the nature of the charge to a degree that might not be necessary in the prosecution of crimes of more limited scope, meaning this is a very particular prosecution. We need more details. And the defense contends that the prosecution should be required to identify victims for several reasons. First, without clarity from the government, Mr. Combs has no way of knowing which allegations the government is relying on for purposes of the indictment. Other than victim one, there's no way for Mr. Combs to undermine who the other unidentified alleged victims are, the number of potential alleged victims, and the length of time alleged in the indictment both weigh in favor of a bill of particulars. By the way, there's been a superseding indictment, so now there are 3 numbered victims in this case: victim 1, victim 2, victim 3. But anyway, going back to the letter, it says, moreover, to the extent Mr. Combs is forced to mount a defense against criminal allegations that the government does not seek to prove at trial, he's entitled to know that. Basically, the suggestion is if the government knows that an allegation from somebody is false, they need to tell the defense that. Quote, absent a bill of particulars, the government is forcing him unfairly to play a guessing game, one made all the more challenging by the onslaught of baseless allegations that desperate plaintiffs are lodging at him, for the most part anonymously, in civil suits designed to exact a payoff from Mr. Combs and others. Second, given the anticipated amount of discovery and the expected time required for its production, Mr. Combs will be unable to adduce the identities of the purported victims from the discovery without the assistance of the government. Mr. Combs also anticipates that the discovery will contain voluminous evidence of consensual sexual activity, making it all the more difficult for Mr. Combs to ascertain which of his prior sexual partners now claim, years later, that they felt coerced. Even if it were possible to ascertain the victim's identity from the discovery, and especially given the volume of anticipated discovery, it is unfair to require Mr. Combs to spend significant time trying to unearth the alleged victims' identities. Now, the prosecution asked for a little bit more time to respond to the defense's letter, which the judge granted. And then at the end of October, the government submitted its own filing, which included some details about its investigation so far, the sheer volume of information they were gathering. It reads, to date, the grand jury has issued over 300 subpoenas, and the government has interviewed over 50 witnesses, several of whom testified before the grand jury. Since the defendant's arrest a little over a month ago, the government has made 3 significant productions of discovery material, which include the following categories of materials: all search warrants and supporting affidavits, hotel, financial, and communication records produced pursuant to grand jury subpoenas, and electronically stored information from over 60 of the defendant's own devices and iCloud accounts, including, among other things, text messages, audio and video recordings, photographs, and documents which the defendant had requested be prioritized. These materials contain additional details about the allegations against the defendant, including, for example, specific allegations relating to multiple victims in search warrant affidavits and communications with victims and witnesses from the defendant's devices. Now, when it comes to the request for a bill of particulars from the government, the prosecutors say that the defense's motion was, quote, both premature and without merit. By seeking a bill of particulars identifying victims under Federal Rule of Criminal Procedure 7, the defendant attempts to pervert the Federal Rules of Criminal Procedure to unduly and prematurely restrict the government's proof at trial and to co-opt the criminal proceeding to defend himself against complainants in separate civil litigation. The court should reject this misuse of Rule 7, particularly in light of the serious risks that identification of victims poses in this case, which, as the court is aware, involves serious allegations of violence, sexual violence, witness intimidation, and obstruction. Basically, the government's saying, don't limit our case right now. There's no need to limit it. And the government cites a court case that found, quote, the purpose of a bill of particulars is to ensure the defendant has the information necessary to prepare a defense, not to turn over all information that would aid the defendant. Another piece of case law states, indeed, the limitation on the availability of a bill of particulars is important, as a bill of particulars confines the government's proof to particulars furnished and therefore can restrict unduly the government's ability to present its case. Basically, if we give you that bill of particulars right now, then we might be just limiting to just what's in that filing, which could hamper our case down the road, especially if we're continuing to investigate what's going on. The prosecution says courts routinely reject requests for victim identities in cases involving crimes of violence and racketeering, especially when the government demonstrates a risk to witness safety, the potential for witness intimidation, or subordination of perjury. Courts also routinely deny requests for bill of particulars containing victims' names on the basis that these requests are in reality a backdoor attempt to obtain a list of the witnesses whom the government intends to call at trial. But notwithstanding the defendant's procedural failure, the motion also fails on the merits because there's no need for a bill of particulars listing victim names here. The defendant has been more than sufficiently apprised of the nature of the charges he faces based on inter alia, the 14-page speaking indictment, the government's written submissions and factual proffers at 2 separate bail hearings, and discovery produced to date, totaling over 25 terabytes of data, including detailed search warrant affidavits laying out details of the government's investigation and evidence. Courts have repeatedly rejected requests for bills of particulars where the defendant has received similar materials. In other words, you should know who we're talking about. And according to the prosecution, you should definitely know who we're talking about because you, sir, allegedly victimized all these people. Now, Combs has denied that, but that seems to be their argument. There were a few more filings back and forth from the defense and the prosecution, delving deeper into their arguments. But then in an in-person hearing in December, the defense says it asked Judge Subramanian to keep the defense's motion open pending receipt of discovery. Now, all of that brings us to what happened on Tuesday, February 18th. The defense submitted another letter addressing witness names, and it reads, quote, "We have since conferred with the government, requesting a list of the anonymized victims and witnesses listed in the Enterprise letter. The government responded that they would provide the defense with this list when they produced 3,500 material on March 21st, 2025. The government has produced over 20 terabytes of information, and it is impossible to do a proper defense investigation as to the allegations in the Enterprise letter in less than 2 months without the names of the individuals, both alleged victims and potential witnesses who are listed in the Enterprise letter." Now, that's interesting because we've talked about the Enterprise letter before. Actually, there were 2 things that they mentioned here, the Enterprise letter and the 3,500 material. But the Enterprise letter, which we were waiting to be filed, we were going to actually do a sidebar on it. It is possible that was already filed under seal at the beginning of the month. If we look at the docket, that seems to be what maybe was the sealed document, because we can't seem to find anything about it ourselves. So based on the statements that you just heard and the docket, it seems that that Enterprise letter, which was going to list out more details regarding the racketeering conspiracy charge, it seems the defense might be in possession of that. And again, the Enterprise letter would give Combs and his lawyers more details on the specific objects of the charged racketeering conspiracy, including, to the extent possible, the dates, the times, the places, the participants for each racketeering act. So it's really important. 3,500 material, which is also referred to as Jenks material, usually consists of statements and reports of government witnesses and their attorneys. And the defense asks of Judge Subramanian, quote, "Respectfully, we seek a ruling from the court on our motion for a bill of particulars related to the alleged victims' names and also to the anonymized witnesses in the Enterprise letter." And at the time of this recording, neither the prosecution nor the judge have responded to the defense's request. But that is not the only important filing submitted this week. No, because the defense and the prosecution jointly submitted an addendum to a protective order involving alleged sex tapes that the prosecution obtained of Combs. Now, the accusation is that there's some sort of malfeasance demonstrated in these videos, some type of coercion or intimidation or proof that Combs may have been involved in the hiring of commercial sex workers or engaging in sex trafficking. Now, the defense had requested that the tapes be turned over to them. Now, the judge denied that request, denied the defense the ability to get copies of these tapes, but it was made clear that the defense, if they want to see it, they will be given proper access to it when they need to. But this week's filing is important because this week's filing reads, quote, "Whereas on January 14th, 2025, the defendant moved to amend the protective order to treat the footnote 3 material as APO material pursuant to the protective order, whereas on January 29th, 2025, the court denied the defendant's application to amend the protective order without prejudice and directed the parties to engage in further discussions, whereas the parties have negotiated the restrictions below to govern the storage of and access to the footnote 3 materials by defense counsel, the defendant, and retained experts." Okay, so when they're talking about footnote 3 materials, this is what they're referring to, a footnote in a defense filing back in October. Most of the footnote is redacted, but it says these materials will be made available for inspection only and not electronically produced. The defendant may view redacted in the presence of defense counsel at the Daniel Patrick Moynihan Courthouse while monitored by law enforcement officials. So basically, you want to view these alleged sex tapes, you got to do it in the presence of law enforcement, which By the way, if you're Sean Combs or his counsel, a little awkward, right? Watching videos of your sexual escapades in the presence of a bunch of attorneys and law enforcement personnel. But look, that's what he's accused of. That's what these tapes seem to be about. But anyway, putting that to the side, there was a lot of concern about keeping these videos close to the vest to avoid the people in them from being identified and exposed. You can understand that. That's despite the fact that Sean Combs has put forward the argument that those tapes seem to prove his innocence, that this is visual evidence of consensual sexual activity. But now, that proposed addendum to the protective order, it lays out how the attorneys will actually handle this highly sensitive material. It reads, the footnote 3 material will be produced via 2 encrypted hard drives to Tenny Garagos, who will have sole custody of the drives, which will be stored in a secure location at the Agnifilo in Trader LLP office. So Tenny Garagos is one of the attorneys representing Sean Combs alongside Mark Agnifilo. It goes on to say, quote, the footnote 3 material will not be viewed on or copied to a computer that connects to the internet, seemingly as a way to make sure it's not disseminated. The password to the encrypted drives will be provided by the U.S. Attorney's Office for the Southern District of New York solely to Tenny Garagos. The defendant's retained audio and visual enhancement expert may be provided one of the 2 encrypted drives. Tenny Garagos may share the password to the drive only with the AV expert. The AV expert may attempt to enhance the audio or visual quality of the footnote 3 material and to independently review and analyze its metadata. This work will be performed by the AV expert on a computer that has internet access disabled while the work is performed. If the AV expert creates any different versions of the footnote 3 material, either video or still image, such enhanced material will be saved to the encrypted drive provided to the AV expert by Agnifilo in Trader LLP. No copies of the footnote 3 material or any enhancements made thereto will be saved on the computer used to perform work by the AV expert. Now, a lot of things here. So first of all, basically saying, look, you're entitled to a defense. You're entitled to have your defense experts review this material, analyze this material, make enhancements where necessary. But we got to be very careful about where this information is stored. We have to be very careful that none of this information gets out, because aside from potentially violating the rights, the privacy rights of these individuals who are on the tapes and causing them undue hardship, that could affect the trial. That could affect potential jury members if they see any of these tapes. It could affect the witnesses from participating or coming forward fully with their testimony. So the prosecution is doing everything in their power to make sure that these tapes do not get out in any which way. It goes on to say, quote, the individuals permitted to view the footnote 3 material are limited to retained defense experts, witnesses who are depicted in the footnote 3 material, and defense counsel or personnel for whose conduct defense counsel is responsible. The footnote 3 material will only be shown to or viewed by the individuals in categories above or in person on a computer that does not connect to the internet. The footnote 3 material or any portions thereof will not be viewed on a computer connected to the internet, any video conferencing platform, or shared via the internet in any way. So what happens to these apparent sex tapes once the trial is over? Well, the addendum addresses that too. Quote, within 1 week following either the jury's verdict or the defendant's plea of guilty, Agnifilo Intrader LLP will return the 2 drives containing the footnote 3 material and any enhanced versions to the U.S. Attorney's Office for the Southern District of New York, which will maintain custody of the drives until such time as the discovery can be destroyed. Now, that's going to be interesting in terms of if he's convicted, what happens if there's an appeal. But, quote, nothing in the agreement limits other parties' ability to offer the footnote 3 material into evidence at trial, and both parties reserve the right to raise objections to the admission of the footnote 3 material into evidence. So it's likely that one of the defenses Combs' team will raise is that Combs only took part in consensual sex acts. It may not be the type of thing that, you or I might do in the privacy of a hotel room or a home, but the defense claims there was nothing untoward that happened, and these tapes will prove it. I actually spoke with renowned celebrity criminal defense attorney Bradford Cohen about that last month. Here's what he had to say.
The fact of the matter is that the big discussion here is whether or not it was consensual or not. And I'm sure they have sex workers that were like, listen, to me, it didn't look like she was under the influence. It looked like it was consensual. I have no idea. I can guarantee you they have witnesses that have said that. Now, do they have witnesses on the other side that say, oh, she might have taken drugs before, or he was bossy, or he made her do this or made her do that? Sure, I'm sure they have witnesses that say that too. So, whenever a defense puts forth something and says it's corroborated by the evidence, obviously they're not going to say what also hurts them. So, I do think that there's going to be witnesses that are going to say it was consensual. They were in a very long-term relationship. I can't imagine that there wouldn't be victims that or alleged victims that would come forward, or alleged prostitutes that would come forward and say, oh, I definitely had sex with her against her will, because that would make them look stupid. I just think this is a very sticky wicket that the prosecution gets themselves involved in when they make all these wild claims during bond hearings and all these things and these promises, and then all of a sudden the case starts to come out and it's not what they promised. And that hurts their case. It hurts their credibility. And I guarantee you there are potential jurors that are watching this.
Okay, so now I want to talk about the other major filing that dropped this week. So Sean Combs is asking Judge Subramanian to throw out one of his charges because essentially the argument is it's racist. So the defense filed, quote, a notice of motion to dismiss count 3 of the superseding indictment, as well as a memorandum of law supporting their filing. And I want you to read a chunk of that memo. So I want you to stay with me here. It says, this case is unprecedented in many ways, but perhaps most notably and most disturbingly, no white person has ever been the target of a remotely similar prosecution. Sean Combs is an extraordinarily successful artist, businessman, philanthropist, and one of the most accomplished black people in this country. He started his first company, Bad Boy Entertainment, based on his vision for a new type of business headed by a young black executive, emphasizing black excellence and achievement. Over the ensuing decades, he forged a path-marking career consistent with that vision. Yet the U.S. Attorney for the Southern District of New York accuses him of being the kingpin of a RICO enterprise, essentially defined as Mr. Combs himself, and claims the purpose of this faux enterprise is to conduct his personal sex life with his girlfriends. There has never been a similar RICO prosecution. It is true that, like many others who have achieved fame and fortune in the world of entertainment, Mr. Combs has employees, staff, personal assistants, chefs, bodyguards, and other associates that he lawfully employs for different purposes. It is also true that, like many other celebrities, Mr. Combs has had complicated relationships with significant others, as well as with alcohol and drugs throughout his time in the spotlight. But that doesn't make him a racketeer or a sex trafficker. And unlike in other cases involving similar charges, there is no accusation that any of the girlfriends were minors or that Mr. Combs raped anyone. Instead, the government has concocted a criminal case based primarily on allegations that Mr. Combs and 2 of his longtime girlfriends sometimes brought a third party, a male escort, into their sexual relationship. Each of the 3 charges in the case are premised on the theory that this type of sexual activity is a federal crime. No white person has ever been charged with any of these offenses on similar allegations, but the most obvious evidence that Mr. Combs has been consciously singled out and selectively prosecuted because of his race is count 3, which charges a violation of the White Slave Traffic Act. The unusual theory of count 3, transporting escorts across state lines for purposes of prostitution, has never been brought before under this act, which has a long and troubling history as a statute with racist origins, used to target black men who supposedly protect white women from them. The use of escorts, male or female, is common and indeed widely accepted in American culture today, and the primary escort service at issue in this case is a legitimate commercial business operating out in the open, frequently featured in the popular media, including a long-running TV series. It is not uncommon for couples using such services to bring a third person, including as alleged here a man, across state lines and into their intimate relations. Yet no other person, and certainly no white person, has ever previously been prosecuted under the White Slave Traffic Act for hiring male escorts from another state. Mr. Combs has been singled out because he's a powerful black man, and he's being prosecuted for conduct that regularly goes unpunished. So arguably, are they admitting that he was transporting sex workers, but it doesn't make it a crime? But he goes on to say that count 3 should be dismissed because this is a clear case of selective prosecution. Wow. Okay, so let's talk about this. The transportation to engage in prostitution claim, the statute, is also called the Mann Act, named for the congressman who wrote it back in the early 1900s, James Robert Mann. And there were concerns that black men were buying white girls to be their wives. And while it still remains unclear whether that was actually happening, Congress passed the White Slave Traffic Act in 1910. The defense writes, what was racist in its inception has often been racist in its operation. The statute's target was black male sexuality, and from Jack Johnson to Chuck Berry, the statute's most notorious prosecutions targeted famous black men accused of deviant sexual behavior. And the defense also addresses so-called freak-offs, these alleged sexual performances that would sometimes last hours, involve drugs, recording equipment. The memo reads, the conduct at issue allegedly involves sexual activity by Mr. Combs and his adult girlfriends. This includes what the indictment describes as freak-offs, instances in which Mr. Combs and two of his girlfriends would bring a third person into their intimate relations. And then a footnote there says, unlike the false narrative spreading throughout the media that Mr. Combs had freak-off parties in which he had sex with numerous people, including A-list celebrities or minors, none of this is accurate, and is not even the government's contention. The government has alleged that FOs happened with two females, both of whom were longtime partners of Mr. Combs and never happened at any parties. And again, it seems that this filing is acknowledging that yes, Combs did hire male sex workers, but that they were hired through an agency. And that agency is not identified in the memo, but it's redacted out. But the defense provides a lot of details. Count 3 in this case is partly based on Mr. Combs' occasional use of male escorts, including a service. And the indictment alleges that the hired escorts using that service and that the escorts crossed state lines to come to hotels where they had sex with women. But redacted is not some secretive underground operation that was previously unknown. It has been operating in the open for over a decade. It has a website and over 10,000 followers on X. As the company's own press page states, its operations have been featured in Playgirl, Glamour, Sheen, Hustler, Cosmopolitan, and Esquire. Its CEO actively courts media attention and has been repeatedly interviewed on national talk shows and the national news. In fact, Redacted and its CEO have been regularly featured on the popular Showtime TV show Redacted, which aired for 6 seasons. According to the CEO, the company's services have exploded in popularity because of this publicity. It is well known that the escorts from blank sometimes indeed regularly have sex with their clients. The company does not explicitly advertise prostitution services, but nor does it forbid or discourage sex. While it does not advertise sex, it has said that anything that may or may not happen between escorts and a client is a matter of personal choice and personal preference between 2 or more consenting adults. To call this an open secret would only be half correct, as it is not a secret. For example, the company's founder has admitted 2 consulting adults, when you're spending a lot of time with each other, things happen. I'm sure it happens. And 2 clients interviewed on ABC's Nightline admitted to having sex with their blank redacted with the news crew's cameras following one couple to their hotel room door. And then, quote, and the escorts regularly and openly cross state lines to provide their services. The company advertises located in cities around the country, including, of course, New York. And it offers travel packages around the country and around the world. Our men will travel worldwide with you if requested. Now, federal prosecutors will have a chance to respond to the motion in writing, but a lot of updates in the Sean Diddy Combs case. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.